everybody, how's it going? And welcome back to Copper Jacket TV. So today is a great day. We just got the decision from the Supreme Court in Garland v. Cargill, which is the FPC case that challenged the ATF's ban on bump stocks. Now, the majority opinion was written by Justice Clarence Thomas, and the majority has overturned the ATF's bump stock ban. Let's talk about it. Hey, real quick, make sure you hit that subscribe button and that little alarm bell, that notification bell, because I think we have some really good things coming down the pipeline here. And if you know somebody that is interested in this topic, make sure that you share it out. Share it on your socials and let them know what's going on. Okay, so let's go and talk about what's going on here. So this was not a unanimous decision. As a matter of fact, it was split on ideological lines. So you have Justice Thomas, who wrote the opinion for the majority, and the majority seems to believe in the rule of law and the laws that Congress actually passes and the text that is in that law, including the Constitution. Then you have the other side, which really seems to be operating here mostly on emotion and advocacy, right? So you have the dissent coming from Sotomayor, Jackson, and Kagan. Now, I want to read you a little bit of Justice Thomas's opinion, but I want you to keep one thing in mind. This was never really about bump stocks. This was about ATF overreach, their ability to make a word salad out of the NFA and the GCA, and their ability to change statutory definition and, their ability to manipulate things so that inanimate objects would then fall under that law. I mean, they basically took it way too far, and they continue to do so. So this is kind of like a referendum on all of their recent, final rules. So it says, June 14th, 2024, Justice Thomas delivered the opinion of the court. Congress has long since restricted access to quote-unquote machine guns, a category of firearms defined by the ability to, quote, shoot automatically more than one shot by a single function of the trigger, end quote. Semi-automatic firearms, which require shooters to re-engage the trigger for every shot, are not machine guns. This case asks whether or not a bump stock, an accessory for a semi-automatic rifle that allows the shooter to rapidly re-engage the trigger and therefore achieve a high rate of fire, converts the rifle into a quote-unquote machine gun. We hold that it does not, and therefore affirm. Now, in the paragraphs that follow that, Justice Thomas and the majority basically explain why they believe that it doesn't change one thing into another, and they cite different examples of why. One being that obviously, and we all know this, there's not a single function. It still has to be reset and then still has to be pulled back. Regardless of whether or not you're getting assistance from anything else, it's still not a single function, which is really what the ATF was relying on here. So they go on to talk about some of those aspects. Now, some of the language in here I do find kind of interesting, and definitely stuff that we could use for, these so-called quote-unquote assault weapons bans, because they like to refer to them as being, exactly like what's used in the military, and they're not. And this actually does kind of clarify that in some ways. And even though I've kind of read through a majority of this, I'm going to say like 90% of it, because I didn't finish reading all of the dissent because it just drove me nuts. But still, I read a majority of this opinion, and I got to say, there's some pretty good nuggets in here that I think we can pull from. Now, Justice Alito, who wrote the concurrence in here to Justice Thomas's opinion, seemed to basically say that, hey, look, my hands are tied. It seemed like he wanted to uphold the ban, but he was forced to follow the law, which is kind of the way that it's supposed to work. You don't have to like it, you just have to follow it. But he basically tells Congress that, hey, look, we've affirmed that this is the way that the law is written, and, everybody must follow it by the way that it is written. If you want to do something, you're going to have to do it yourself. You're going to have to write new law, basically, in order to clarify what's written in the NFA and the GCA. Now, when it comes to Sotomayor's dissent, it's pretty much exactly what you would expect. I mean, it really kind of gets tiring when you read it. It's ideological where, they look at something, they look at an event, okay? And then that event made them very upset. And somebody used one of these things during that event, and so we have to make sure that we ban everybody else from ever using them either. And so I'm going to also play some really interesting word games here in order to make it seem like that person and anybody else should ever have them. I mean, that basically breaks it down. That puts it in a nutshell for you. It's one of those things. I'm sure you guys have seen them, but it's basically one of those things that says, look, I'm going to put a bunch of legalese in here. I'm going to talk about, what Congress wrote and what's in the GCA. I'm going to talk about those things, but realistically, I don't really care about them, so we're just going to move on from that. That's kind of what I got out of that dissent. There's a lot of interesting things in there, but really they don't matter to me. If you're not just consistently following what the law says, then I pretty much just don't care. So anyway, I wanted to share that with you guys today. That's very big news. We'll continue to pick apart this opinion and see, you know, some of the stuff that's in there that could help us in other cases as well, because just like with the opinion in Bruin, right, which was a Kerry case, we got a lot of positive benefits from that, you know, Kerry case. This could also offer us a lot of positive benefits, so we really need to pick through this and see what we can get out of it. Anyway, I want to thank you all very much for watching. I really do appreciate it. Another great day here. You guys have a good one.